another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
Hey, everybody. I am attorney Michael Ehline. I am an attorney licensed in California and Texas. I primarily do catastrophic injury cases. I've been practicing law for a little over 20 years now. And prior to that, I was a paralegal. I've externed for the California Court of Appeal. And I've done quite a few habeas petitions in my lifetime, and volunteered a lot of my time pro bono when I first started out in civil rights and appellate law cases. Hey, Ralph, good seeing you, buddy. I came today in horizontal. I come in peace. So I'm glad you joined me. And so today I'm going to cover a little bit about what's going on with Lane Myers again. And Lane Myers is being held against his will as a criminal defendant in Pima County, I think men's jail, if I'm not mistaken. And I just wanted to sort of make a retraction. First of all, I thought that he had entered into a plea deal yesterday when I was doing my live stream. And the issue is that the audio from the court was so distorted you couldn't hear anything. And we know that the prosecutor, the city prosecutor, who's married to an alleged victim of Lane Myers, who's also a public servant who works for, I guess, a college or a university, filed a petition that, in my opinion, lacks any and all legal merit. It lacks any kind of foundation. It's all based on speculation and his own opinion to prevent litigants or parties from audio recording in court. And of course, as a result, the only way you can get audio recordings, I guess until the Supreme Court rules on it, is from the court itself. And the audio was so terrible yesterday that I just couldn't hear it. And we were trying to turn it up and trying to figure out what was going on. Hey, what's the matter you? It's What's the Matter You Wednesday, by the way, guys. What's the Matter You Wednesday? What's the Matter You is, I think, one of my longest standing, I guess you would call him like the devil or the angel on my shoulder. He's always convicting me and constantly reminding me of things that I may say or do that might be hypocritical, but I'm only human. What's the matter you? So that's why you're here, brother. I'm loving it though. I'm glad you joined me today, bro. Whenever you're not here, it's like this whole show sucks without you, man. Because I'm not one of these guys who wants to have my butt kicked. I want to have varying and differing opinions, as long as you're respectful. I mean, I'm not going to personally attack anybody. He's one of my moderators, and most of the people that are part of Team MPE do not see eye to eye with me. Many people say I'm a little bit right of Attila the Hun, but actually I am a natural law advocate. I believe that all of our rights come from a creator, just like it says in the Declaration of Independence. I believe that the Constitution incorporates by reference all of our founding documents, including the unanimous declaration between the states by reference. It says right there in the year of our independence, right, 1776. So that's an incorporation by reference, and I believe that is, and I know that is, in fact, incorporating by reference all of our founding documents all the way back to the Magna Carta, except where otherwise abrogated by American common law, because under American common law, our natural law system, which is what our Bill of Rights was based upon, is natural law. All of our rights come from a creator, and the Constitution was designed to bind the government and prevent the government from infringing upon our unalienable rights under the Republic. And so when I first started watching Lane Myers, I was blown away at this guy. I thought, this guy's out of control. He's talking back to the judge. He's going to get found in contempt. He must be crazy. And I started watching the guy more, and I was like, wait a minute, this guy makes sense. And I started listening to him even more, and I was like, this guy sounds like me before I became a lawyer, and it embodies everything that Mike Ehline stood for prior to Mike Ehline becoming an attorney. And so I've sort of jumped on the pro Lane Myers bandwagon to support him in any way that I can, as well as his family, because I believe that he has been unjustly imprisoned based upon my understanding of the law. as it would be interpreted in California or Texas, where I'm licensed. So I'm not licensed to practice law in Arizona. I don't profess to be an expert on Arizona law. I'm in the process of petitioning to get waived into the Arizona bar, but that will be a time-consuming process and probably will be fought against by certain people involved in the Lane Myers case. But we'll let the cards fall where they may. It appears as though people in Arizona are badly in need of somebody like a Mike Ehline who stands up for we the people and is not easily influenced or undermined by the deep state, by the Marxist-run courts and whatnot, as many people call it, that sort of flowed from a very Marxist-run education system. Let's face it, public schools and universities might as well have a hammer and sickle flag. And so once we'll see what happens. But in the meantime, don't take anything I say as legal advice. Do your own research. I teach people my understanding of the law. I don't profess to know more than the average guy on the street if they were just to do their own research. I think being a member of the bar is an office of public trust, and it's my duty to try and be a straight shooter and call them like I see them. And like my father said, it's better to be defined and be hated than to be wishy-washy and not respected. Because my dad always told me that if you're defined, even if people hate you, they'll respect you, and it's better to be respected. A little Machiavellian, but I don't think so. I think it's more what people want to hear. Even if you hate my guts, at least you'll respect the fact that I am entrenched in my positions, unless you can prove me wrong. And I'm the first person, if you can prove me wrong, who will admit that I'm wrong. I'm not somebody who's going to sit there and argue with you and try to be right like a lot of these people on YouTube. So good seeing you, Steve Conkler, Let's OTVO, good seeing you. By the way, Let's OTVO, the plan is to go live on Friday with BZ Watchdog and Ryan, the angry Texas cop, the former cop turned whistleblower, to break down BZ Watchdog's arrest. And I'm hoping that you'll talk to him, that you and Brick will talk to BZ, so he can also present what happened to you guys, so we can cover it and, try to do a fundraiser for you and stuff. Hopefully you guys have some kind of a link where we can try to raise funds for you, because I know that you guys were falsely arrested recently. So, and what's the matter with you? I think that is your philosophy too, bro. I think that we have to respect other people's opinions, but we can't insult them and tell them that they're stupid or they're wrong. That doesn't, right. And what's the matter? You has a problem with Ryan. Well, look, Ryan was a cop, and so I have a little bit different position. I think that some people get into public office. Some people want to become law enforcement or corrections officers because they think that they took an oath to uphold the Constitution, and they think that they can change the system from within. The same way that I became a lawyer to try to change the system from within. And I've held on to my values. If anything, they've become more entrenched and stronger. Being a pro-Second Amendment advocate, working with Alan Beck, and now we have the Department of Justice signing on to his brief. It's just unbelievable. So it just proves that if you stand tall for what you believe in, beautiful things can happen. And as a result, Team MPE and I have built this channel, I think, from around 3,000 subscribers to a little over 50,000 in, I think, just about a year's time. And I think it's just because I call it like I see it, and that's how it's always going to be with me. So what's the matter? You does say he doesn't have a problem with Ryan, and that he's glad that Ryan's trying. So again, Ryan was a whistleblower, and he exposed some bad cops, and as a result, he's no longer a cop. So I don't know what to tell you guys, but I've represented many, many whistleblowers who were police officers, and I can tell you pretty much with very few exceptions, they were either former U.S. Marines or Navy with a really strong sense of duty and honor, and they thought that when they retired from being property of the U.S. government, that they could somehow get into law enforcement and do the right thing. But then they found out with the police unions And with the Blue Line gang or whatever, that they weren't able to achieve that mission, and they either turned whistleblower or they retired and got into private security or something like that, which is really sad. It reminds me of that movie Mr. Smith Goes to Washington, right, with Jimmy Stewart, where he thought he was going to go to Washington and make change, and he found out that it was pretty much impossible. And we know that the CIA, as well as Hoover, remember Hoover? He had dossiers on all the politicians that could hold them hostage. We recently discussed a case about the U.S. Supreme Court where they all had book deals from Penguin, right? Penguin Books, or at least 4 of them. And they had to disqualify themselves from a case that very well could have gone against Penguin Books, the same book company that had signed very lucrative book deals with these justices. So it always makes me a little curious, like, why did you guys withdraw from the case? Because somehow there was a conflict of interest, or is it because the facts were so overwhelming and the law was so overwhelming that you would have had to have found against Penguin Books, the same people that you have a lucrative book deal with, where you get book royalties, for example? So, and a lot of people say that Justice Roberts, he's I guess chair of an organization that investigates, like sort of like a commission on judicial performance, which is allegedly an executive organization, right? So it should be controlled by the executive branch, but yet he has exclusive authority over it, apparently with some other judges, to decide whether or not to investigate charges of, kickbacks, book deals, et cetera, against maybe Justice Thomas, for example. So you're not going to see me here supporting left or right. I'm just saying I think everybody could be potentially corrupted, and I think that's the whole idea of having a two-party system instead of many types, like Libertarian Party and all this other stuff. Having a two-party system makes it easier for billionaires to control either party, and I believe that that's probably what's been going on. But there are allegations against Justice Roberts that he engaged in an unlawful adoption of his children in Ireland, where I guess by law you have to disclose where you got the kids from. Like, it can't be a secret adoption. So many people say that somehow he either unlawfully did this deal in Wales or did it in Mexico in order to skirt those adoption laws. So it's really, really interesting. And hey, Steve Conkler, thank you, guys. Everybody give me a bunch of ones for Steve Conkler. Looks like you got a 350 Chevy on there, Steve. What is that, a Chevy Nova? What is that chassis on your image there? By the way, I'm going at you today on What's the Matter You Wednesday in horizontal, because as we move further into the show, we're gonna do some more of the ghetto lawyer observation stuff, and we're gonna cover what's going on with Letitia James and the boomerang effect of her and her Marxist Democrat Party over there going after Donald Trump, getting Trump because she ran to get Trump, which is a violation of the state bar ethics guidelines, running for political office to basically prevent a president from running for election. That's probably interference with an election. So election interference, right? So all kinds of cool stuff we'll cover today. And again, guys, thank you for being patient with me. As you know, I've kind of blew out my back, so it's been kind of rough. But today I'm at my standing desk, so probably my feet will get sore before my sciatica flares up. So I'll try to go as long as I can. While I can, I took the day off so I wouldn't have to work on files today, so I could bring this to you. So before I get started, we're gonna talk about what happened with Lane Myers. We're gonna talk about the plea deal, which is unbelievable. I'm just blown away. So it looks like last Friday, apparently, and I don't know for a fact, I'm just going on my notes. And again, guys, I don't know everything about the case. I tried to call Reluctant Prophet earlier today, but couldn't get through to him. But it looks like the other judge, the first judge, I think his name's Metcalf, if I'm not mistaken, apparently Lane wanted to enter a plea. This is my understanding, okay, is that he wanted to enter a plea last Thursday or Friday, if I recall correctly. And wait, it was no, Judge Metcalf, I guess, Judge Douglas Metcalf. Okay. And he had filed a petition to remove this judge because he felt the judge was biased against him. And So that hearing had to be, and apparently he also had entered some kind of a plea deal or was going to enter a plea. And correct me if I'm wrong in the sidebar. If I'm wrong, it's a 63 Nova. Okay, all right. Well, I was close, man. 427. Right on, dude. So you're an old schooler. I love 427s. I built 350 Chevys and 327s with my dad in the garage when I was growing up. He was a big time drag racer. Put a 327 in it, or put a 350, because later it was the 350. That was all the rage. But always he would say put a Ford rear end, because Ford has stronger rear ends, and we would build those. And he also helped me restore a 356A Porsche, a 1956 356A. And we also had a 1959 356A that we put a 350 Chevy in. Man, that thing was a hoot, man. We had that thing all souped up, and you could hear that thing coming from a mile away. And in the 356A, we had the original motor powder coated, and we set it up and just put it on bricks in the garage. And we dropped in I think it was a 2000 cc dune buggy motor from a Mickey Thompson super off-roader guy who rolled his dune buggy. And we bought that motor and we put that in there. And I had to put like 45-pound plates in the trunk to keep that front end from lifting off the ground. And they both sounded amazing. So yeah, man, we had a lot of fun doing stuff with my dad. He used to drag race on the 22 freeway with his friends. I've told you guys this story before, but for the people who are just joining me, he used to drag race on the 22 freeway while it was under construction with his friends. They'd go up against the Mopar guys, the rich kids who could afford, the heavy duty Mopar stuff. And him and his poorer friends, my dad made all of his money off of a paper route, right? And he paid cash for a brand new Corvette when he was in high school from that paper route, believe it or not. And anyways, they would drag race, obviously, for pink slips, and the police would come and watch while the 22 freeway was under construction. So just to give you an idea of how it was when our parents grew up, if you're my age, they were almost all military veterans from World War II, or at least merchant Marines. They all participated. They all loved America. They all pledged allegiance to the flag, and they were super pro-American all the way. And everybody had a gun, at least one in their house. Nobody was doing mass shootings. People were educated. They were taught English lit. They were taught Latin for the most part. Most of the kids that my dad grew up with, even if they were poor, they were taught classical education, Latin, and they had a much better, broader understanding of our country than most kids nowadays. Nowadays, kids go to school and the public school teachers try to convince your boy that he's a girl, your girl that he's a boy. The college professors take your normal daughter, and by the time they're done with her, she's wearing a Che Guevara t-shirt and burning American flags and waving rainbow flags saying down with America and down with the USA, which is exactly what the funders, Communist China and their Confucian societies wanted, which was originated initially by the KGB and then taken over by the Communist Chinese. I mean, what a great way to destroy a country than by using their education system, right, guys? So in any event, back to Lane Myers. H Factor, good seeing you. Constitutionally Correct says, got you talking about yourself. I guess I can go cook some lunch. And back before you get to the original subject. Well, actually, I appreciate that, brother. What I try to do is give a couple of minutes for people to come in and join the chat, because a lot of people don't get my notifications. And so Team MPE will come along and notify the other members and moderators to come in and join me. But in any event, Lane apparently had a hearing before Judge Lewis, I guess, yesterday. And this is a female judge, so a different judge, and it had to do with a change of plea, and also, I guess, Reluctant Prophet, and this is a public service, also wanted to be heard because they wanted to do media. They wanted to be able to audio record. And so it looks like, we didn't get the audio. It was so terrible, unfortunately. So I thought that he'd entered a plea, and so that's what I was telling everybody. Hey, it looks like Lane entered a plea. I see on here that there's a plea, and we couldn't hear it. So no, Lane didn't enter a plea. Apparently, he tried to withdraw or alter or change a plea. And so we're going to get into that in a minute. And it looks like the court just outright dismissed and rejected outright dismissed and rejected the request to audio record, at least from Reluctant Prophet, aka Mark Kelly. And they just wanted to record the live stream and the change of plea hearing. And apparently there were 3 hearings on schedule that day in front of Judge Lewis at 9:15 in room 805. And there was a media hearing at 9:30, and I guess that was the media hearing for Mark Kelly. And it looks like there was a motion to recuse Judge Douglas, or that's the thing. I don't have put it in the sidebar if you guys know exactly what happened here. But in any event, that Lane had a motion to recuse a judge that was hearing the case. I think it was Douglas Metcalf, and then to try to change his plea at the same time. And so what happened? I looked at the Pima County portal, and I couldn't find any information on Friday. And I'm just going down my notes here. It looks like Judge Metcalf extended a live stream. Hold on. A lot of the frauditor people are saying that Lane was filing a motion to recuse the judge because the judge had ruled against him a bunch of times. Well, that's not why he was trying to get him off the case, guys. I'll just let you know right now. He's trying to get him off the case because the judge was dismissing motions, and in Lane's mind, and in the minds of many other legal experts in Arizona, was simply making short shrift of his motions and making improper rulings and denying Lane due process, procedural due process. So that was the reason why Lane was trying to get him off the case. And just really quickly, just let me go down my notes. So bringing it back full circle, that's when I when I joined the stream yesterday and just could not. Yeah, right. And Grateful Dab says that the judge was biased as hell. Well, that's another reason that people agree with Lane's position that this judge is biased and he needs to be removed from the case. Hopefully that's a little better. I'm just trying to get my camera just right. You know what I'm saying? All right. So really quickly, what we'll do then is we'll go into my first video, which is Reluctant Prophet. And we'll let Reluctant Prophet sort of tell you what happened, and we'll go from there. So here we go.
Welcome back. Welcome back. Welcome back. Welcome back.
Well, let me know your concerns or what you would like me to consider me on. And it's Miss Walker, correct? Yes. Yes. Your Honor, thank you for the opportunity to speak. While I understand that the specific sentencing details, including any prison time and probation conditions, will be determined by a later stage, and will be followed to now. These conditions are critical to a proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to the many crimes he has committed against you. In doing so, he's acknowledging that his conduct does not protect his speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These were not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again that he's unwilling to follow court orders.
So this is it sounds like the prosecutor narrating a alleged plea agreement that Lane was going to agree to. It sounds like. And so I was, based on the shoddy audio, saying, guys, it looks like Lane pled out, which makes sense because 95% of criminal charges result in a plea deal. And what is a plea deal? Well, typically you'll You'll plea out to a lower charge, a lesser included offense typically, so you can get less jail time or get probation and get the hell out of the jail, right? And in this case, we know that according to Lane, he was attacked by at least one of the correctional officers, and we know that he was promised by the original judge who confined him that he would have access to a law library, which there was no law library to begin with. Apparently, the law library had been removed from the prison at least 2 years ago. So there was no way for Lane to get his pleadings. There was no way for Lane to respond to any pleadings from the prosecutor, because by the time he got them through prison mail, for example, it was already past the statutory time to reply. And what was the judge's response? Well, you could file a motion. You could file a motion. I mean, it was like, to me, in all candor, it reminded me of One Flew Over the Cuckoo's Nest. Have you guys ever seen that movie with Nurse Ratched? It's like, you can file a motion when we already know he's not going to have access to the law library. We know that although he has assistant counsel, there's no way his lawyer can rush down to the prison and go through a check and take his shoes off, go through all that alarms and detectors, and get an appointment to see his client and still get the responsive pleadings filed in time. It's impossible. So many people say that the prosecutor's office was working in conjunction with the court system to deprive Lane of his unalienable rights, to have a timely hearing, to have notice and opportunity to respond to pleadings, and hence, like the Jan 6ers, put Lane in a position where he had no choice but to enter a plea, because how was he going to get justice? And I did cover in my last show, where I had Lane on as a guest from jail, that there is a way to do a federal removal. But the problem is it has to be done in a timely fashion. And how could Lane have moved for a federal removal when he was confined and not able to file motions, not able to have access to a law library, despite being promised by the judge that he would be able to have access to the prison law library that didn't even exist when he was promised? You guys understand why Lane probably wanted to recuse the judge? I mean, give me a bunch of ones if you think that you would want to recuse the judge too, based upon those facts. And if I'm wrong about the facts, I'm more than willing to issue a retraction. My goal here is to not insult the judiciary or any other lawyers involved in this case, but to simply say that I feel that this whole case has been wrongly decided and wrongly prosecuted. And I believe that Lane, had he had more experience and perhaps been doing this longer, would have handily won this case from the very beginning. But I just think because of his lack of knowledge when it comes to procedural and substantive law, from just being a practitioner and understanding how the system works from within, that it prevented him from having that overwhelming victory here. That's just my thought, because I believe that Lane has a superior knowledge of the law. It's just that there's more to the law than just the law. There is politics at play here. And I believe that his lack of understanding and his innocence with respect to thinking that he would just get justice is probably what prevented him from getting justice here. And I think that a lot of people who are just starting out in law feel the same way. They think that, well, we've got this system, it's going to be just. But they find out after they've been practicing for a while that there's more at play than just the black letter law and the procedural rules. Give me a bunch of ones if you've been in practice and you agree. Give me a bunch of twos if you think I'm off base and that Lane is like the holy messiah and that he can do no wrong. Now it says here, hold on one second, guys. So I've been taking these nicotine patches because allegedly nicotine can destroy what do they call that stuff? The nanotechnology that they're putting in our food and trying to inject us with to control us. So I want to make sure I have a clear head for you guys. So Luke says, Lane's judge change was denied. He then tried to enter a plea deal, but the judge rejected it because he wouldn't admit his actions caused the victim reasonable fear. The alleged victim, and in Reluctant Prophet's words, not even victim, the complainant, basically, the complainant. So, and I agree with, I thought about this after I talked to Reluctant Prophet the other day. Calling someone a victim when there's been no trial on the merits to make someone a victim creates a appearance of impropriety to a jury and to the public at large. You're not a victim until it's been adjudicated. And there was never an adjudication that the wife of one of the prosecutors who lost against Lane, who then forwarded charges to a criminal county prosecutor to get felony charges against Lane, there's never been a finding of fact or conclusion of law that this person is a victim. This person is a complainant. And I thought about it. I was like, you know what? You're right. That creates an appearance of impropriety. What do you guys think? I think it does. I think it absolutely does. I think it's right on the money. Hey, Stomper, good seeing you, man. I think it does create an appearance of impropriety, and I think that it's unjust to call an accuser a victim until a jury or a finder of fact has made findings of fact, and the finder of law, in this case it would be a judge, has made conclusions of law that this person is a victim. I understand that an injunction or a restraining order involves determining whether or not the alleged victim, or in this case the complainant, had a reasonable likelihood of success at winning their case. And if the judge finds that the complainant, aka what they call a victim, had a reasonable likelihood of success, then an injunction or a restraining order could be issued. And that's all it is. So I think that it makes more sense to call it accuser versus accused. And that's how it was at common law. And so I think just by virtue of calling Lane's accuser a victim has already biased his case. And so I agree with Reluctant Prophet on that. And I think that this is something that should be taken all the way up. I think that the Supreme Court and the state bar, as well as the legislature in Arizona, should make it clear that you're not a victim until you've been adjudicated as a victim. You should not be calling someone a victim until they're actually found to have been a victim in a legal court of law with proper notice and opportunity under the 14th Amendment. Give me a bunch of ones if you guys agree. And look, it just blows me away that I'm getting this feedback after over 20 years in practice as a lawyer from people who aren't lawyers, just from regular people that have jobs and businesses who are struggling to survive like Reluctant Prophet, but who have good hearts and they want to help their fellow man. And it's very rare that you'll find lawyers like that. Most lawyers that I know and that I've met are pretty much just in it for the money. And so that's one of the reasons why I do this show. Number one, to show you that we're not all like that. And number two, because I'm a patriot first, and I took an oath to uphold this Constitution, and I take it pretty seriously. So that's why we're here today. So let's see here. And now, will not comply says all liars are lawyers. That's probably true. But not all lawyers are necessarily liars. And remember, you can be a lawyer without being a member of the bar, but you can't be an attorney without being a member of the bar. Remember the distinction. So I consider Lane Myers to be a lawyer. I think that he's well educated in law, and I've offered to have him study under my license to become a California attorney on the law study program. I think he'd make a terrific attorney. And I think once Lane learns the politics of the judicial system, I think he's one of these guys that would probably win every case, probably settle every case without having to go to trial. He just needs to learn the basic rules of civility, but you can win people over without winning over them. And I think that most of you guys who have watched my show understand that I 100% support Lane's mission of holding the government accountable in a peaceful, nonviolent fashion. So now Luke says alleged victim is certainly fair. YouTube character limit. Wanted to provide the gist from the hearing, from the full hearing. Absolutely, bro. Absolutely. So let's go ahead and get back into Reluctant Prophet's video. And hopefully RP's watching. I did ping him and I did try to contact him, but haven't heard from him so far. Let's keep going. So again, it sounds like the prosecutor narrating to the court her conclusions and factual allegations against Lane, that Lane has to admit basically that he's a stalker, that he had no First Amendment rights, et cetera, et cetera. And so that's at the bottom here. So let's go.
Based on his behavior, I do not believe that he's capable of complying with probation without strict and unlawful oversight, along with serious consequences if those terms are violated. Any plans for procedures should ultimately be accompanied by a period of incarceration, which I understand will be determined by the death path, as well as strong enforceable probation conditions that are specifically designed to protect me, my family, and the community. These measures are necessary, not only.
So it sounds like that's the alleged victim, right? Is that the wife of the prosecutor who lost the case against Lane originally? The so-called victim, is that her making these statements on the record? I'm not sure. It's either her or the prosecutor. Somebody in the sidebar, let me know what's going on. If you could, please.
To reflect the seriousness of Mr. Minor's crimes, but to ensure that I and those close to me can report his safety. When the court considers sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case is. Thank you.
I think it's time for this country to take back our country. This is an issue of government transparency. We can't trust a government that does not trust its people. We're going to uncover the cover-up, and I hope this is just the beginning of more people coming forward about this.
So it looks like Reluctant Prophet is going to cover some more of this later on, but based on my understanding, and I'm looking in the I'm looking in the comments right now, it appears as though that was the alleged victim. That was the alleged victim who was making those comments in the court. And Dara says fake victim. And then, okay, the tribe says after law school, the A students work for B students and the C students become judges. Oh, well, I think that that's actually a factual statement. I found that the A students typically get government jobs and they limit their incomes, and they're typically the ones who believe anything the government says, kind of like the communist Chinese, right? Whatever the government says is true. I remember when I worked at the prosecutor's office, that the prosecutors always wanted Asians on the jury because they believed that Asians would always find in favor of the prosecutor. And so defense would file motions all the time. It's either Wheeler or Walker in California to basically say, wait a minute, this is a biased jury. They're just trying to get all black people on the jury, for example, or all Asians so they can get a conviction. So really interesting the way that we're not allowed to talk about the cultural implications in a trial, but it's real. It really is. It happens all the time. Statists, that's right, statists. That's what Will Not Comply calls them, statists. And the tribe says law school is acting class. Well, what I found, and what I have found, and this is why my kids are homeschooled, by the way, is that public schools were brought here by the Rockefeller family from Prussia. And the King of Prussia lost a battle against Napoleon, and his troops retreated and mutinied against the officers. And so the king got basically like the social theorists of his day together and created a public school system. Basically the Pavlov's dog type of a system where there's a bell, kind of like a prison. You know, you march in step from class to class. There's a bell that dismisses you. And you can see, obviously, how it works. Social engineering, right? And now you have young boys who think that they're girls and young girls who think that they're boys. Well, where's this coming from? Well, look at any public school campus. Far left Marxist advocates who spent their time at Berkeley or some left-wing run university. They love getting jobs around children, especially males of a certain persuasion. They love getting jobs around kids and trying to convince them that they're something that their parents have told them all their lives that they're not. And so we see that happening quite a bit. And so, yes, I do agree with you, the tribe, that school in general, public schools, publicly funded schools, schools that receive grants, do want to create a class of workers and not of thinkers. And that was the idea behind Rockefeller bringing that system from Prussia to the United States and using grants to say, look, I'll build you a schoolhouse, I'll expand your school, these, classic schools, the way they used to be, where they taught you cursive, they taught you Latin, they taught critical thinking, and said, look, I'll give you a bunch of money and I'll help you expand your schools. And then ultimately, once he'd done that enough, he was able to create a powerful lobby and then go to Congress and start creating the public school system. And then ultimately, Jimmy Carter, I think he created the Department of Education, and we've seen our education system in a downward spiral ever since, with schools being used basically to socially engineer students and brainwash them into being good little Democrats, for lack of a better word, as opposed to teaching them critical thinking. And I think that law schools are also a byproduct of that. Very rare to meet a judge modernly who really supports the Second Amendment, who really understands the Bill of Rights or the Constitution, except maybe on the Fifth Circuit. I've met a few, but other than that, pretty rare, pretty rare. So that's my opinion. And then let's see here. Hey, I like the tribe more and more. The tribe says lawyers support school board property taxes to ensure schools don't teach the law and logic. It's a financial arrangement. Well, I think it's more than that. I think that the vast majority of lawyers were brainwashed, just like the vast majority of public school kids. That's why I keep telling you guys we should support creating parallel systems where we work with each other like the Amish do, and we homeschool our kids, we homestead, we get off of the government brainwashing system, and we just do business with one another. Like Team MPE, like when I need silk screening done, I'm going to reach out to one of the members of Team MPE to get that done, even if I have to pay a premium. So I don't have to participate or buy things from some corporation that supports the World Health Organization or the World Economic Forum, population control, forced injections, and all that stuff. So that's just where I'm at. And I'm hoping that as I do more and more of these shows, that more and more of you people will see the value in a system like that, because less than 3% of our population actually took part in the revolution against the king. And remember, the primary impetus, the primary driver of that Revolutionary War was the king trying to seize our powder houses, which is where our gunpowder was stored, in order to fight against the government. And we see that what is the number one thing that leftist public school teachers and Marxist college professors want to do? What is it? Take away your Second Amendment rights. Why do you think that is, guys? Why do you think that is? It's really interesting to me. We can talk about that in another show. Now, GNC says I can't get a good mic. So are you guys not hearing me? I mean, I'm trying my best to, let me see if I can get the mic a little closer. Is that a little better? Sound a little bit better, guys? Let me know. Huh. It's for your safety. Well, give me some 5x5s if you think that my sound is okay. If not, I'll try to mess with the gain a little bit. Okay, Tom says it's okay. All right. Now, Simba B says that Lane exposed that, and even if he tried to get out by pleading, the court would not let him out. Well, that's interesting. So what it sounds like is that Lane tried to enter a plea that the court didn't agree with, or that Lane basically on the record made it clear that he didn't agree that he had stalked or done any of these things that he had to admit on the record, right? So that's what they do, is they force you. I don't know if you guys are familiar with the Knights Templar, but the leader of the Knights Templar was tortured and forced to admit that he was engaged in blasphemy, right? And so as a result of that, when he was burned at the stake, he retracted that statement, and I believe it was on a Friday the 13th. And he said that the Pope and the King of France, who was trying to seize all the property of the Knights Templar because he was in debt to the Knights Templar, would all face their peril and doom because of what they did to the head of the Knights Templars. And sure enough, Friday the 13th still to this day is remembered for that. And sure enough, that's exactly what happened. All those people met terrible fates after they destroyed the Knights Templar. So let's see here. Just trying to see. Okay, now What's the Matter You says Lane knew ahead of time that the plea wouldn't be accepted. And I've heard that as well. A lot of people are saying that this was part of Lane's grand strategy to get the other judge recused and to create an even further record that he was being denied his rights. So that's pretty much that. Let me see. And then I'm going to just really quickly go over, let me see here. So I did an interview with Lane from jail. And here's some snippets. And then I'm just going to go ahead and get into that interview with you guys so you can kind of see what led up to this. All right. So here we go. Yeah. Express or implied threats.
So either I caused people to commit the crime of threatening, or they didn't break the law and it's constitutionally protected activity. There's only one type of speech that's not protected, that's not constitutionally protected activity, and that's true threat. So if somebody made a true threat, then they should be prosecuted, because their case falls apart when they say, well, because first of all, I have all this stuff. There's nobody that made a true threat. And if they did, they should be prosecuted, not me. And so, or we both should. You get what I'm trying to say?
Yeah. Express or implied threats.
So either I caused people to commit the crime of threatening, or they didn't break the law and it's constitutionally protected activity. There's only one type of speech that's not protected, that's not constitutionally protected activity, and that's true threat. So if somebody made a true threat, then they should be prosecuted.
So that's Lane basically saying in my interview with him last week that his reading of the Arizona revised statutes is that the only time something's not protected speech is if you're truly threatening someone. And I've gone through all of the videos and all the evidence that I could find, and I can't find any case where Lane is actually making a threat. Now, I did take a look at the harassment statute and was able to find that it's such a poorly written statute and so unfair that the Arizona legislature is actually in the process of redrafting it. Because basically what it says is that if you feel like you're being harassed and you're what the court deems to be a reasonable person, right? Which, I mean, if you're from Berkeley and you're a flag burner, that might be reasonable to that particular judge, right? So if that's a reasonable person, then that means that it's a foregone conclusion. You're guilty of harassment. And obviously that is a violation of equal protection and due process. And as applied to Lane, that statute was unfairly applied. And so I agreed with Lane's prior associate counsel or friend of the court. The motion that his prior counsel filed, I thought was pretty damn good. And obviously, if I had been on that case, I would have immediately gone up on a writ or tried to do removal to federal court if it wasn't already too late based upon civil rights violations. Because I believe that statute is an abomination, the way that it's drafted. If this was in California or Texas, that's the way I would have handled that particular case. And give me a bunch of ones if you agree, if you've seen that motion. If not, I'll try to find a link and post it in the description of this video. I believe that I have a copy of it somewhere. Let's take a look here. And then Simba B says, well, I'm not going to name names, but that the parties against Lane are the ones doing the actual harassing. Let's see here. So Hedera says, Lane got to tell the entire story. They didn't make any time restrictions or interrupt when they thought he was pleading guilty. So that's really interesting. So remember that he was always given time restrictions. You have 5 minutes to do this. You have 10 minutes to do that. But when it came time for Lane to go and throw himself on the sword and become a victim of the state, all of a sudden there were no time restrictions. He could talk all he wanted about, I'm guilty, get it on the record. I did this, I did that. I'm a terrible person. So really interesting, guys, right? I mean, just if you're following the story, to me, this is just unbelievable. So anyway, so that's that. And what I'm going to do now is, let me make sure you guys can see the screen. We're going to get into my interview with Lane just from the short period of time that I had to interview him while he was in jail. Well, from the jail, because he's still there. And I'm trying to get another interview with him to go over some of the pleadings that he's filed, et cetera, et cetera. So hopefully you guys, if any of you guys run across Reluctant Prophet or This Is a Public Service, please let them know to please get a hold of Lane and let's arrange another call, but allow me to review the charging documents and motions, et cetera, beforehand so I can ask Lane some decent questions and just give Lane an opportunity. If any of you guys have been to jail or even like we're in boot camp, especially in the Marine Corps, it's like being in prison. Just being able to talk to someone, having someone on the outside to hear you out, just so you know that you're appreciated and that people care about you, it's like life and death, man. It is super important. I remember just getting mail from my dad when I was in boot camp. He would write me every day. It was so awesome. just that hour of time or half hour of time that we had at night to go through and read our mail it meant all the difference in the world. It gave me that energy to make it through to the next day. So just like the Navy SEALs say, guys, the only easy day was yesterday. And I'm hoping that you guys can send that message to Lane if you hear from him before I do. Hey, Lane, the only easy day was yesterday, brother. Keep it up. Keep up the good fight, man, because there are people out here who do care about you and won't prejudge you. All right, so let's go ahead and just listen to some of my interview with Lane the other day so you can get some context to what led up to this hearing the other day. All right, man. So hopefully...
Chili's on the phone too?
Yeah, he's watching, and we're trying to get Team DLZ to support you as well. There's times when we all have to unite to try and rally around people who we feel are being unjustly imprisoned.
People try to make it seem like I don't like chili because I make jokes about the trifold. No, that's like means I like you. It's like you know how you like make jokes with your friends? Like it's like most of the time your friends don't get mad. Like I know chili don't. Other people that try to stir the pot, they're like, oh, because I've made jokes like, oh, the trifold. But I also made it clear that at least he's trying to do something. It's better than fucking sitting back and trying to get other people put in jail.
Yeah, well, Chili says he's got nothing but love for you. And I think that most people who actually care about the Constitution and the Bill of Rights, they also feel the same way.
Right. It's just easy, you know, the divisive people that, because I've made some jokes about the trifold, but I've also always qualified it by saying at least he's trying to do something. You can criticize his work or whatever, but you can't criticize his effort. I've never seen, and to be clear, disclaimer, I've never even seen the trifold.
Okay.
I just was recycling jokes that people make. You get what I'm saying? It's fucking comedy on YouTube too.
Yes, and then just to let you know, we've got a couple hundred people in here, and so I just wanted to share with you. Buzz says it's only the trolls that don't like you. Kevin Briarnarski says hi. FPV Frodo says hi. I don't know if you know any of these guys. I just know that when you're locked up, it's nice to know people are thinking about you. Jody Shiloh says free lane. Yeah, she says free lane. Janelle says tell Lane all his shareholders are here saying that we miss him. So yeah, you know, Quanah Parker, one of my moderators.
They're just sending emails to the prosecutor and the people that are accusing me. You should see some of these crazy emails. It's like, yeah, okay, somebody's sending the exact same. You know who Eric Brand is? Have you heard of that case?
Yeah. Sorry. Go ahead, Lane.
Word emails they're sending. You've heard of the Eric Brand case?
Yes, I have.
All right. Well, somebody I know who, because we have their information, is sending the same emails that Eric Brandt sent. The only difference is Eric Brandt sent those items. So they're sending them, but I'm not, because obviously I'm in jail. You know what I'm saying?
Yeah, they're trying to make it look like it's you or your supporters, right?
Right.
Yeah, that's typical.
Right. Yeah, you know how it is.
But by the way, Chili says, you know, how are you doing? How are they treating you?
In jail?
Yeah.
They're treating me like a prisoner, you know, like an inmate who stands up for like himself and doesn't let them, demands what he has coming in jail. Like, and then the other day they punched me in the chest a couple times because I got drug out of court, and the dude was like, "Who's your daddy? Who's your daddy?" Or "I'm your daddy," not "Who's your daddy?" "I'm your daddy." You know, they know I shouldn't be here. They're sick of me too. You know, not complaining, but like discussing why I'm here, and it's all bullshit. You know, they don't want to hear it.
Well, you know, I know that John Felax was talking about getting that body cam footage. I'll follow up on that and see what's going on with that.
Yeah, hopefully they get that and expose the cop who did it. It was ridiculous. He punched me while I was in shackles.
That's unbelievable.
So, while saying, "I'll take these off right now and we can do this right now," some big fucking guy, like 350 pounds. I'm like 160 right now. I've lost 13 pounds while I've been in here.
So
and
they punched you while you had torture cuffs on?
Oh, yeah. While screaming, "You're a big idiot for being your own lawyer. I'm your daddy, and we can do this right now."
That's
with other cops standing there recording it on their body cam, too.
That's crazy.
All the other cops were like, "Yeah, make sure you put a complaint on them and get the body cam." I was like, "Oh, I'll do that for sure."
Well,
I guess he was supposed to come in there and set me straight. You know what I'm saying?
yeah. Were you able to get your were you able to get your hands on a practice guide like criminal practice and procedure?
No, I can't get it. There's no law library like they say there is. They keep lying to the court saying there's a law library.
Well,
I could probably, is that I could order on Amazon?
I'll talk to Reluctant Prophet about it, and this is a public service, and see if we can find a way to get you one. I know that when Chili was in jail. Yeah, I know. Oh, you cannot get mail?
Nope.
Well, how are we going to get you a book?
I'm telling you, man, it's a whole scam. No mail.
Okay, now Lane.
Somebody tried to send me. Rejected.
Lane, my understanding is that the judge promised you that you would have access to the law library before he incarcerated you. Is that a fair statement?
Yeah, that's all fucking hot air. That's all for show. That's all for, that's all for the record, to make it seem like they gave me due process, but they didn't. So then they can say that I had an advisory counsel who was Parvin, who was useless, and then they could say, well, you didn't, your lawyer, that's between you and your lawyer. Not, we gave you a fucking advisory counsel if he didn't give you what you need, you know what I mean? That kind of thing. So it's just passing the buck, for lack of a better term. It's saying, oh, well, I didn't abuse my, all the buzzwords for the appeals, it's like, oh, well, you received due process because you had an advisory counsel. If the advisory counsel wasn't that good, well, that just means he wasn't that good. It doesn't mean you didn't get due process. Oh, we said we had a law library. Well, there must have been a law. The judge said you had access. You must have had access. The prosecutor files a notice saying I have access, and then the jail says that's a lie. Put us on the stand. There's no name. She said she talked to people at the jail. Well, she didn't put their names. Nobody at the jail said, when I showed them what she said, they said, no, that she didn't talk to anybody here. She just said that because if you talk to somebody, you'd say, I talked to this officer, John Smith. And instead, she didn't put any names, no affidavits, no nothing, no written statements, nothing. It's just gaslighting at the highest level. It's, oh, well, because we filed this piece of paper, then, we're the state and we said that he has access, but he doesn't actually have access. And then I tell the judge to have an evidentiary hearing and bring the people from the jail who will testify different to what Rachel says. And then the judge, if you've been paying attention, the judges.
He said to file a motion, as I recall.
Yeah, he's something special.
Now, I have it on good authority that the entire courts system, as well as the prosecutor's offices, knew or should have known that there hasn't been a law library at that jail for the last 2 years. Is that a fair statement based upon your knowledge?
20, they're telling me 2018, 2019. Before COVID, there hasn't been one.
That's shocking.
So even more than 2 years.
By the way, Let's OTVO, he's a part of Team DLZ. He follows your channel. He just said in a super chat that freedom is more than a feeling. Speech is not an action. No victim. I'm no crime. No hands or time. So he just wanted you to see that. And I just want you to know there's people here.
Yeah, what's crazy, I could have punched this bitch and fucking misdemeanor.
And then Brett Ray says Lane needs his dogs. I agree with that, but you must miss your dogs.
Oh my God! Don't even get me started today because me and my wife were talking about that. Yeah, definitely need to get back to my dogs because I just need to get back to my whole life. Like, what am I doing sitting in here again? I can't remember. Can somebody please tell me what?
So, guys, I just got an email from a member of Team MPE that has some snippets of the motion to withdraw plea, the motion to recuse the judge. So you guys can go to my YouTube channel and you can watch my interview with Lane the other day anytime you want. But now that I've got some additional information that just came in, that's why I love doing these shows, because you guys provide me with information that I can then disseminate to other members of Team MPE. So let me just really quickly. So this is a public service, and this is a snippet. Again, so we're going to go from the actual
there's no video or anything. It's audio. So, but hopefully we can hear it, because the other day I couldn't hear anything. And I was just devastated, thinking that Lane had pled out and that he was going to get released and be on some kind of crazy probation and have his life ruined. Worse than it already is. Well, let's go ahead and make sure we got the sound up, and let's go ahead and try to listen in about what happened here.
The change judge.
On the change of judge, sir, are you ready for that motion? If you, I don't know, I'm sure you have seen my order. What I did was give you 20 minutes, to make any oral arguments that you would like. And then I'm giving the state 15, and then I'm giving you 5 minutes to rebut anything the state says. But let me make clear before we proceed that what I have read is the motion for change of judge filed by Mr. Myers. I received a response from Ms. Stiles this morning that I read. And then I had an excerpt done of the transcript that I spoke about at the beginning of this hearing because of some quotes you had made, and I wanted to see what the official transcript would have.
Thank you.
So I requested that. It is 8 pages. It's really 7. The 8th page is just a certification, but on the first page is like a heading. But so there's the other pages were parts of the transcript, and that was from a May 12th, 2025 hearing, just so the record's clear what I read and reviewed. I believe that is everything I read and reviewed. Do you need a second, Mr. Resnick, or is it okay?
I'm working on something else.
Okay, that's fine. I just want to make sure. Okay, Mr. Meyer?
Point of order on the motion that Rachel or Ms. Stiles filed.
The response?
Yeah, it's technically not valid because she didn't serve it on me properly.
Okay, go ahead with your,
Because I have to get, like, I have, if she filed this with the court on the 23rd, I needed a copy on the 23rd. Because I have 3 days to respond. I've received it outside the window to even respond. That makes it stricken from the record. That's clearly in Rule 1.9 that if the motion isn't properly served, it's stricken from the record.
go ahead, Mr. Myers, with your argument. You have 20 minutes with regard for the motion for change of judge. Anything you want to add to your written memorandum?
Do you want me to review what I've already written, or?
So basically, you've got Lane saying that anything filed by the prosecutor, because he did not receive it in a timely fashion, should be stricken from the record. And he's citing the actual rules of court. And we have the judge not ruling on his oral motion to have it ignored, basically. What do you guys think about that? That's really interesting. So you can see I'm trying to scroll the transcript for you people. In fact, let me see if I can make it. There we go. So just read along and I'll try to scroll as best I can.
However you want to use your 20 minutes is fine, sir.
All right, thank you. So to start with, the motion was filed based on the May 12th hearing, at the May 19th hearing, and I believe I'm allowed to introduce things that are not in the motion too, right? Because
If you've got something you think is important for me to consider.
the May 19th hearing is when the rule of changing judge has to be within 10 days of the.
Okay, I think we're okay. Sometimes the microphones do weird things.
It has to
Okay.
be within 10 days of the, incident, for lack of a better term, incident. I believe they call it the trigger event or something. So that would mean that the May 12th hearing, I would need to get it. Is that because?
I wonder if it's your phone, Mr. Resnick. I don't know. I'm guessing. It's a guess thing. Sometimes. No, you can move it over if you see it. Let's see if it does that again. Okay, Mr. Myers, go ahead.
Pursuant to the rule, you have to file it within 10 days. So being in jail, that already makes it tough to get anything filed within this, there's some limitations on just being able to file, like e-file, you can just e-file, right? So May 12th, I decided I wanted to, it was actually leading up to that because he started denying.
So what Lane is saying is that, look, I've got all these statutory time provisions that I have to abide by, like respond in a certain time, file something in a certain time, triggering events that are all time constrained, okay? But he's not able to do that because he's locked up. And of course, the original judge, I think it was Metcalf, said, well, if you've got a problem with that, file a motion. And then Lane's like, well, how can I file a motion when I don't have access to a law library? I don't have papers and pleadings. And my advisory counsel is advisory counsel. I'm lead. How can I lead my case when I'm being denied the ability to be lead counsel in my case? And I think that those are great arguments Give me a bunch of ones if you agree. I think that Lane is on the right track here. And the other issue I have is assuming arguendo that Lane has made some kind of a procedural mistake. Under Balistreri versus Pacifica Police Department, a Ninth Circuit case, which I've shepherdized and found other cases that are on point, including state court cases, the Court of Appeal has a duty to ensure that pro se litigants don't lose a fair hearing on the merits of their claim due to ignorance of technical or procedural requirements. Well, in this case, it's even further and deeper than that. It's not an ignorance of a technical or procedural requirement per se. It's that he's being denied the ability to abide by the technical and procedural requirements. So there's a lot more to it, guys. And I'll be honest with you, I think that Lane's got testicles of steel, because a lesser man, 95% of these cases result in a plea deal, and it's usually unfair to my client. And they're just so pressured, they just want to get out of jail, they'll plea out. So give me a bunch of ones for Lane, sticking to his guns, guys. I mean, I'm really impressed by this guy so far, but let's keep listening.
He denied, like, you just went through this whole hearing about 122 and you said you had no problem with 122H. So the very first hearing, he banned 122H throughout the whole entire proceedings.
Okay, and then 122H has to do with being able to audio record in court. And again, if apparently there's like a temporary stay that was filed by actually the husband of the alleged victim, the claimant in this case, to prevent people from, like Lane Myers, from audio recording in court, which has always been the law that you could audio record from court. And somehow or another, after Lane beat this guy in court, he files this motion on his own to, as far as I'm concerned, when I've read it, it's baseless. It's all pure speculation and opinion and conclusory with zero foundation. It's just this prosecutor's opinion. And I have not seen a responsive brief. I saw that, like, I went online and I voiced my objection to this petition to have the Supreme Court change the rules so the First Amendment is given less protection in the Arizona courts, like it is in California, basically. And I'm just blown away that the Bar Association, court commissioners, pretty much everybody that has anything to do with the judiciary or the bar are voting in favor of suppressing the right of free speech and not allowing audio recordings unless it's through the court. Well, the problem is the other day, we couldn't even hear anything because the audio recording from the court was so terrible. So let's keep listening.
And that's against the Supreme Court rule. And when questioned on it, he said, I can do whatever I want. You know, I said, well, how do you overrule the Supreme Court? He said, well, I can do whatever I want in my courtroom. And if you don't like it, give a special action. But that's not really truly how it works, as we just saw here.
Special action in Arizona would be, I believe, like basically push for a writ, like a writ of mandate or a writ of prohibition. So that's, I guess they call that a special action in Arizona.
122 is the Supreme Court rule. So right off the jump, we were already, but I didn't want to go to a special action after the first hearing on my judge that's going to preside over my trial. So I let that one slide. And then, you know, a couple back and forth, he was refusing to give the bond hearing right from April 4th when it was initially filed. I know that I referred to it from May 12th, but this started April 4th. The initial bond hearing was filed by Parvin on April 4th.
And Parvin was his prior associate counsel, right? Friend of the court, just so you guys know who he is.
He, as of April 28th, he was still doing research. Well, what research do you need to do on a rule of procedure that's black and white? So that had us, you know, I don't want to say at odds, but, you know, we had a disagreement about the time frame of that, and he refused to rule on it. But then he had no problem ruling on a motion to dismiss the same day it was fully briefed. So he took, you know, 4.5 weeks to still do research on a motion for bond eligibility that's a procedural right. And he took, you know, 4 hours to rule on a motion to dismiss that has serious implications for both me and defendants across the state of Arizona. He didn't seem to need to do any research there. So that got my radar up. And I told him that I would be filing a Rule 10 because, you know.
So Rule 10, I believe, would be equivalent to what we call a 170.1 in California, which is a challenge for cause. They're rarely granted. They typically have to be heard by the presiding judge. And I believe then it can go all the way to the Supreme Court, if I'm not mistaken. So again, I don't know what the exact procedural rules are in Arizona, but That was the goal, is that Lane was trying to get this judge recused because he believed that the judge had an inability to perceive the law or some kind of a personal bias that prevented him from ruling in a lawful manner on Lane's pleadings and motions and promises that he was made by the judge, like he would have access to a law library, when no law library had even existed for at least 2 years prior to Lane being incarcerated.
I didn't feel like he was being impartial, because it seemed like the Ms. Stiles could file a recipe for an apple pie, and I could file a legally cognizable motion, and her motion would be granted. So at that point, I started to wonder. Okay, I said, Your Honor, I believe I'm gonna file a Rule 10. That was at the April 21st hearing. However, I had no way of filing it because Parvin was still my counsel, and we had to have the Ferretti hearing to get him off as being my lawyer, so I could even file my own motion. So being in the jail, I have, my only remedy is to mail it. Well, I requested envelopes at the jail on April 17th. April 28th, they said they would get them to me. I still didn't receive them until May 9th, so I wasn't even able to file the original one. So that was leading up to that. The 10 days passed and I couldn't file it. So now moves us to the May 12th hearing. So at the May 12th hearing, I had moved on from the original Rule of 10 because I thought, I just want to get this process moving. So at that hearing, we started going over these preliminary issues, and that's when the motion here began. But I want to pause right there for a second and jump ahead to the day I tried to file this motion. The May 12th hearing led to me wanting to file it. So May 19th, I come into court, before the judge is even on the bench, and I made it clear this motion needs to be filed before the hearing starts for it to be, binding. I handed it to that gentleman was in there, a different woman though, and let him know, hey, this needs to be filed before, because I'm making, a request that needs to be done before the hearing. Once the hearing starts, it's too late, and it's got to be within 10 days. Everybody was aware of the spirit of what I was trying to do. I'm in custody. I'm at the jail. We had a hearing on May 12th. I go back on May 13th and write the motion. Had I put it in the mail that day, it still wouldn't have went through the mail system and got there prior to the hearing, because that was, just Monday to Friday. So if I would have...
Again, this is a procedural issue, guys, like I was telling you before. So typically, the Court of Appeal, or in this case, the trial court, would have to give Lane additional time if he was ignorant of this procedural rule to file something in a certain amount of time. But here, the power of the state, whether it was being done on purpose or negligently, right, or just giving him short shrift, the power of the state denied Lane the ability to file his responsive or moving pleadings in a timely fashion. And so just that alone is a denial of substantive due process. And so because of that, I feel that this is exactly the type of case that should be removed into a federal jurisdiction based upon denying Lane Myers his substantive due process rights under the 14th Amendment. And this is just my personal opinion if this had been in California or Texas. And again, I did tell you guys earlier that in order to do a federal removal, it has to be done based on strict time requirements. And the issue, I think, with Lane is, number one, he was never allowed the right to represent himself the way that he needed to. And once he was incarcerated, he was denied the ability to file timely responsive pleadings. And had Lane tried to move for a federal removal, I don't know that it would have been granted, because they could have just said, well, it wasn't done in a timely fashion. So I just wanted to hopefully give me a bunch of ones if you understand the nuances of what is going on here. Because if, in my opinion, if all of this stuff that Lane is saying is true, this has the appearance of a kangaroo court. It really does. And it's unfair to me. And I don't understand why the State Bar of Arizona isn't up in arms over this. If the State Bar of Arizona truly wants to support we the people, as opposed to their own, like prosecutors and people running for judge or political office, it would seem to me that it would be fair of them to at least give Lane's arguments some credence and his position some credence and speak out against this, or maybe file a brief against what's going on, or join as amicus counsel to one of Lane's motions or briefs where he details the unfairness and impropriety of what's happening to Lane. All right, let's keep going.
Put it in the mail Tuesday night, say it goes out Wednesday. It still would not have been in the court's possession and filed before the hearing on Friday. So I thought, okay, I'll bring it to court, make it clear I want to file this before the judge comes out. They made copies. They had it ready. They set it on the desk. He comes out, and right then and there, I say, Your Honor, before we proceed, I want to do the Rule 10. So he pulls the book out. Oh, what is Rule 10? He looks it up. He said, oh, it has to be filed before the hearing. Oh, you're denied. You have to do it. The hearing already started. I said, but Your Honor, the spirit, you have discretion. He has discretion to overrule the Supreme Court. He has discretion.
Yeah. So what Lane is probably arguing is that the court has inherent sua sponte power to effectuate orders and rulings so as to comport with fundamental ideals of fairness. And in this case, what Lane is saying, well, you had the authority to just out of hand make short shrift of my other pleadings. But in this case, you won't allow a hearing on my Rule 10 to have you recused for bias and unfairness. And you're ruling against it out of hand without even hearing it, claiming that it had to be filed beforehand. But Your Honor, by incarcerating me the way that you did and denying me the ability to file motions and pleadings within the statutory timelines, today was the only time that I had to file this motion. And you have an inherent sua sponte power. You have inherent sua sponte power to comport your ruling so as to allow this motion to be heard. Now, the prosecutor could argue, well, we the people should have a right to file a counter motion against it. And that might be true. But in this case, because it's a direct motion, a direct attack on the judge's bias, it would seem to me, at least in California or Texas, that this case should immediately cease and the motion should be heard before another judge who's allegedly impartial.
Discretion to, take 7 weeks or 4.5 weeks to rule on a bond motion. He can dismiss motions within the same day. So the judges do have discretion. That's a word that gets thrown a lot with judges, discretion. So everybody back and forth where I said, well, Your Honor, I'm trying to do that. He said, I don't care. I said, well, what am I supposed to do? I'm in jail. How can I get it to you any sooner? And he said, and this is where I believe is just a cherry on the top of everything that he's done to me. He said, well, you're the one that chose to represent yourself. Well, that's right there. He's saying you're prejudiced because you're representing yourself. You're unable to do what you need to do because you're prejudiced by being your own attorney. And he's refusing to.
Look, I agree 100% with Lane's argument. If what Lane is saying is true, the judge is basically saying, because you chose to represent yourself, you're not entitled to due process. That is the way it comes across to me. Give me a bunch of ones if you agree that that's Lane's argument. And to me, it sounds like a fair argument.
The little bit of grace that would have took to say in the spirit of what I was trying to do, that he has the discretion. Instead, he tried to force me to have the hearing for the bond, despite me trying to file this motion before the hearing so that he wasn't the one that ruled on it. He could have used his discretion so that he wasn't the one that ruled on it. He could have used his discretion. Instead, he chose to say, well, that's the consequence of being your own attorney. No, I shouldn't have any consequences. And he should have just said, you know what? You're trying to file this. It's no skin off my back. I'm going to accept it as it because you clearly did everything in your power in custody and in here today to get it on my desk before. But instead, he just, nope, I'm not doing it. And then I said, Your Honor, you're just blatantly violating the spirit of the thing. And he said, you're misbehaving, and he removed me from court. Now there again, right there, Rule 9.
Interesting. So we got knocked offline.
Why the fuck is the live stream offline? See what I mean with these people?
So, okay, so this is a public service. And so that's the problem that I have, guys. Listen to me very closely. That Rule 11H thing allowed parties to audio record and stream as well, live, what was going on. Notice how as soon as there's something that could make someone look bad, maybe on the court or a prosecutor, all of a sudden the live stream gets cut off. Whether it was on purpose or not, it has the appearance that they're trying to deny Lane the ability to let the public understand what's going on with this case. And that's why I think that this petition that was filed by Mr. Walker is fundamentally unfair to we the people. And I believe that this now has formed the basis of all of you people who live in Arizona to start moving for recall elections immediately. If you really want to make change, where the hell is the recall petition? That's what I'm trying to understand. Let's keep listening, and hopefully it'll come back on.
Wow.
So this is a public service talking.
So either he needs to remove me from court and put me somewhere where I can still observe the hearing, or he needs to give me a chance to say to the security, hey, I'm willing to quote unquote behave and take me back in. That's literally written in the Rule 9.2. You get removed, you get one chance to say, I'm going to behave if you know, they say, are you willing to go back there and behave? Yes, sir. Okay. If you go back in and don't behave, you're gone for good. Well, he didn't even give me that. They took me straight to the basement and one of the guards assaulted me. So, but that's handled in a different sense. But so now back to the May 12th, because now we can see that he didn't even want me to.
By the way, guys, I'm going to be honest with you. From the first time that I heard Lane Myers argue in court to now, to me, he sounds like a very polished attorney. Aside from the fact that he doesn't know all the terms, he doesn't have this huge, expansive vocabulary, everything that he's saying flows very well. And to me, as a layperson, not just as an attorney, I'm a blue-collar guy who became a lawyer later. I'm compelled to support Lane. It really, if I was on the jury and I had the right to rule on the law, Lane would already be out of jail.
File this for some reason. So the arguments I have are the media was denied from the beginning, okay? And for no other reason than the victim, but it didn't comport with reality because the court is live streaming, but the people can't audio record. That doesn't add up.
Doesn't add up.
Excuse that the victim. Well, how is the victim harmed any more by somebody sitting back there with their phone recording than audio only? Than with the court broadcasting it and somebody recording that. That doesn't comport with reality. So that right there, because I have a right to a public trial, media coverage. We've touched on that in this little hearing that we just had. Your interpretation of the fairness of the media being allowed in the building versus being able to video. You reached the compromise of 122H. That's not something that you can just take away. Even your admin order says, 122, we follow it strictly. We're going by 122. 122H says you can. 122C and all that means that you can have a hearing and use your discretion. So that's what I felt he should have did. At no point did he use his discretion. He just banned it throughout the whole case, which that takes away each person's ability to argue for themselves. But the real thing that matters.
And we just saw that happen where the audio got cut out, right? So Arizona law made it clear that you could audio record in court. And then the alleged victim's husband, who's a prosecutor, files a petition with the Supreme Court because of Lane Myers. And then all of the court commissioners and the State Bar of Arizona jumps on and supports the prosecutor. I mean, it doesn't give a very good look to the State Bar that the State Bar is there to be a neutral party and uphold the rights of the people, does it? It looks to me almost like a political thing, right? Like, oh, you mess with one of ours and you're just a little person. You don't have a position of public trust. So we're just going to railroad you. That's the appearance that it gives me. Give me a bunch of ones if you agree.
This is this non-bail eligibility hearing where you file a motion under the rule and you're supposed to get a hearing within 7 days. He took it to, so the motion gets filed April 4th. As of April 21st, he was still doing research to decide if he was going to have a hearing, No, that's not the rule. That's not the case law. The case law is clear about this, that it's a matter of right. You file the motion under Rule 7. When there's a change of court, the court was changed. The de novo standard is re-examine means renew. The Court of Appeals is defined what they mean by re-examine. That means a de novo review. So the only way you can de novo review somebody who's not eligible for bail as a matter of right is to have another evidentiary hearing, because you're
Mr. Lewis, just so I'm sure which one are you referring to?
7.4C.
Okay.
Yeah. 7.4C. It says that
it's kind of shocking to me that this judge is even allowing Lane to talk and not trying to kick him out of the courtroom. I'm getting the feeling that this judge is actually probably agrees with Lane. And this is the issue that I have. A lot of people are complaining about is that since judges are elected officials and that they're appointed by the governor, that a lot of times, many people argue this, and I'm not saying this is true or not, that they'll make political decisions because they don't want to disallow themselves of getting money to get reelected, et cetera, et cetera. But if I was a judge, I would rule on the law and the law alone, not based upon my political biases. And because of that, I believe that millions of followers that Lane has picked up and the hundreds of thousands of people that have been tuning into my program, the ones who live in Arizona, would vote to install that judge in a position of leadership, perhaps governor, mayor, et cetera, et cetera. And that's how you should run for office, by standing up for the people and the rights of the people, not the rights of the state, because the state is supposed to be bound by the chains of the Constitution, not the other way around. And this is so far, so good, Lane. You're kicking butt, buddy. I can't wait for my next phone interview with you. You're winning me over big time, buddy. You're really doing a good job here. Let's keep going.
On a motion, the court on its own, sua sponte type thing, or on motion, can re-examine bail eligibility. Well, the plain meaning of bail eligibility, everybody's eligible for bail as a matter of right, except people who are not eligible have been held not eligible for bail as a matter of right under the 7.2, presumption, what is it called? You know what I'm trying to say, where they find proof evident or whatever, you know what I mean? At the initial hearing, they find it, and then you still got to be indicted though. So that you have the initial one, you still got to be indicted in the justice court, it gets brought over to the superior court, and you can move to re-examine bail eligibility. Well, the plain meaning of bail eligibility is you're not eligible, or you're eligible as a matter of right. Everybody's eligible except this limited class of people that get found proof evident. So right there, he said, well, that's not how I interpret it. Well, there's no other way to interpret it when the Court of Appeals has made it clear that the word re-examine in that rule means de novo review. Well, de novo means you throw everything that happened away and you start over. To start over for somebody who's not eligible for bail as a matter of right is to have another evidentiary hearing.
Right.
It's right in the case law. And I realize we're not arguing that motion right now. Which I've been trying to do for 7 weeks now. I've been trying to argue this bail motion, I'm being held with no bail and denied the chance to argue why I should get bail. The state should be forced, because the things they held me for, one of them didn't even get indicted it got indicted as a misdemeanor. So you're being held for these felonies. Well, one of them was a misdemeanor now. So I should get a chance to re-examine bail eligibility, the plain meaning of the word, and then the case law says two reasons you can do that: transfer to new court or new material facts. I was transferred to a new court. I applied for a bail eligibility hearing. It's a re-examination. Re-examine means de novo. Well, we got Metcalf going, well, I don't really feel comfortable looking over Judge Miller's shoulder. Well, no, that literally by rule, procedure, and controlling case law,
that's what you're supposed to do.
What you need to do. You need to take what Judge Miller did and set it over here, pretend it never happened, and start from scratch. De novo, review anew, start over, de novo review. They start over. That's what that means. So he's letting the state file, like I said, a recipe for apple pie, and saying, oh well, your motion's denied because the recipe for apple pie says you don't get another hearing for bail. And that's right there. That's intentional disregard for the rules. That's not being impartial. That's being biased. That's being prejudiced against me. He's not taking my argument serious because I'm pro se.
That's right.
There's no other defense attorney in this court.
That's what it sounds like to me. It sounds to me like the judge has already said on the record, it's your fault for representing yourself, and that's why you're being denied procedural due process. That's why you can't file motions, et cetera, et cetera. So it's on you for making the mistake of representing yourself. And to me, if this was California or Texas, I would argue that shows overwhelming bias against a self-represented party. And it seems to me that would be a valid basis to seek recusal. What do you guys think? I'd like to know what you all think. Let me just look in here. Yeah, you have the right to remain silent says that the 9th, 8th Amendment to the U.S. Constitution prohibits cruel and unusual punishment. Many people say that that's exactly what's happening to Lane right here, that they're basically trying to force him to enter into a plea bargain by denying him the ability to adequately defend himself, which is precisely why we have a Bill of Rights. It's why we had a bloody revolution. And so it's really amazing to me to see what many people say seems to be the English courts, the King's courts, reestablishing themselves right there in Arizona. And that's the problem a lot of people have with this case, guys.
No other judge in this court, no other defendant in the state of Arizona has to wait 7 weeks for a bail reexamination. That's a procedural right. It's a procedural right. It's not even something the state can argue against when it's a procedural right. You have the right to this re-examination. It's not, oh, well, we'll decide if you have the right to have, you can file a motion and you can ask. No, you file a motion, you get the hearing. It's that simple. That's one thing. Now, the denial, the speedy trial, when he was setting the trial, I said, Your Honor, you have to set the trial in enough time to have sentencing before the speedy trial runs out. He says, no, you don't. No, you don't. That's not how it works.
And what rule is that?
That's case law. It's in my motion. It's case law. It's in my motion right here. Speedy trial. Right here. That's State versus Bartlett, 179 Arizona, 109, 876, page 2D at 114. Court of Appeals, 1993. In light of the foregoing authorities, we hold that the guarantees to speedy trial found in the Sixth Amendment of the U.S. Constitution and Article 2, Section 24 of the Arizona Constitution apply through sentencing. So him saying, no, if you don't like it, file a motion. No, I don't need to file a motion because it's literally been it's been affirmed since 1993 that in light of the foregoing authorities, the guarantee to speedy trial applies through sentencing. So when I say, Your Honor, you're not leaving enough time from the trial to sentencing, to do the sentencing, the whole sentencing, you got to wait, you got to go through the pre-sentence, all that, before my speedy trial runs out. He says, oh, well, sentencing doesn't apply. And when I say, yes, it does, it's case law, he says, well, if you don't like it, file a motion. No, I don't need to file a motion to uphold my constitutional rights. That's not how this works. It's not, well, you have this constitutional right, and I'm going to use my discretion today to decide if you have that constitutional right. And if you don't like me taking away your constitutional right, you can file a motion or a special action and make yourself sit in jail for another however many months with no bond while the case is stayed, so we can decide that you do have the constitutional right to a speedy trial.
That's
not
crazy.
How this works. And he wouldn't do that to any other attorney. He did it because I'm pro se. And so that's a big thing when you're taking away a constitutional right. And we sit here and talk about, you have all these rights and you're innocent until you're proven guilty and you have this due process. Well, I don't have due process because he's telling me if you want due process, you have to file a motion to get due process. No, I have due process when I wake up in the morning. Everybody in this room does. Every single case that comes before you, ma'am, that applies to, it's a constitutional thing. It's not.
By the way, you're not allowed to call a judge ma'am or sir. You have to address them by your honor. I learned that the hard way. Being a Marine, I always would address the female judges as yes, ma'am, no, ma'am. And they would just get infuriated, especially the feminist judges. They hated it. So that's one thing as a pro se litigant, you can get away with stuff like that. But at least in California and Texas, you have to address them as your honor or judge, et cetera, et cetera. Just a little tip for you, especially if you have like an Obama appointed judge or maybe a they, them judge. They may get upset if you call them by the wrong gender, for example.
Judges.
Oops. I don't know what just happened. Hold on. Let me try to get back to where I was, for crying out loud.
The change judge.
On the change of judge, sir, are you ready for that motion?
So where was I?
I don't know.
Where I was.
I'm sure you have seen
Dagnabbit.
my order. What I did was give you 20 minutes. Yeah, to make any
Well, somehow
oral
or another, I
arguments that
lost
you
where
would
I
like.
was.
And then I'm giving the state
I'm
15,
gonna-
and then I'm giving you 5
I'm gonna go
minutes to
back and
rebut
try to-
anything the state says. But let me make clear before we proceed
one
that
second,
what I
guys.
have read is the motion for
If
change of
anybody can
judge
help me with the
filed by Mr.
timestamp.
Myers. I received a response from Ms. Stiles this morning that I read. And then I had an excerpt done of the transcript that I.
If anybody can help me with a timestamp, that would be helpful. Somehow or another, I must have clicked the wrong button and I lost where I was, but I'm going to open up the freaking heckin' A, guys. Go to the transcript. Somebody, if you can, rewind it back I'm trying to just get the damn transcript to open up, and it keeps on trying to. Looks like Big Brother's trying to mess with me, guys. I can't even open the damn transcript. Hold on.
The change judge.
On the change of judge, sir, are you ready for?
It looked like we were about 40 minutes in. Is that a fair statement? I don't want live chat. I want transcript. So look what happens, guys. I click on the transcript, show the transcript, and what's going on? Where's the damn transcript? Oh, guys. Just bear with me here while I try to find the transcript again. So I'm clicking on the transcript and nothing's happening. So I'm going to refresh. I'm going to go back because we were getting to the good part, right? Hopefully you guys are having a good time. So far you've kind of seen how this works. Lane is acquitting himself well with his arguments, and I'm quite impressed. Okay, so here's the transcripts. Let's get to, I'm thinking we were around 35 minutes or so in on this thing, right? Let's take a look. And let me take a look. What do you guys think? 4414. Stand by. Thank you, guys. Thank you for supporting Team MPE, by the way. It's really kind of you guys. And look, I'm not, again, I'm not licensed in Arizona. I'm just doing this because I care about Lane and his family. And based on what I see as a private citizen, I just really think he's getting railroaded big time. I think this has been very unfair to him and his family. Let's keep going.
Moving on to the jury questionnaire. He allowed the state to argue that the state would be prejudiced, which the state doesn't have a right to a fair trial. Only I do. The state does not have a right. That's in case law, up and down. The state has the right, the defendant has a right to a fair trial. The Sixth Amendment, all the rules of procedure guarantee the defendant a right to a fair trial. They don't guarantee an impartial, they don't guarantee the state to a right to a fair trial. And how can the state be prejudiced by the truth coming out? The state should, if the state if their charges are based on the proper factual basis, and they're not in bad faith, and they're doing everything by the book, how could somebody talking about their case prejudice the state? No. So they were worried that if a jury questionnaire went out, people would go to my YouTube channel and see what they're doing to me. Well, how's that any different than somebody gets charged with murder and KGOT9 does a story about them being charged with murder, and they interview the victim and the witnesses, and the state gives a little,
Mr. Mayor, you've got about 3 minutes.
All right,
I gave you a couple extra.
I appreciate it. The state has no problem when a murder murder suspect is on the news. They don't claim they're being prejudiced that a city of 1 million people, the jury pool is going to be tainted. What are they saying that? A couple hundred people are going to watch my channel, and then they can't, out of 1 million people, they can't find enough people to have a jury. So the state does not have a right to a fair trial. I do. And if I want my story out there, that's my right to have my story out there. And if a couple people read it and check my channel, that doesn't disqualify every single potential juror in the city of 1 million. Now, moving on to the retaliation thing, as you saw in the transcript, he said, word for word, I said, he said, we're going to have the hearing, I have a trial next week, then how are we going to have it within 7 days? We're going to come back on. And I said, no, you're going to follow the law, you're going to get out this case. He says, I don't like threats. It's not helping your case. How is that a threat? What threat am I saying? You're going to follow the law or get out this case. I have the right to file a motion for a change of judge. How is that a threat? Threatening to what? Follow the rules of procedure? And I said, was that a threat? He said, you're threatening me. And I said, you're threatening me now. And he said, no, you're threatening me. You're telling me if I don't do what you want. I said, no, I'm telling you, you need to follow the law. And he says, okay, and I need to read what it is. And I said, you don't need the law, right? So how is me saying quote unquote threatening. No, I was implying that I'm going to file a Rule 10 motion on him. He's saying it's not helping your case. So me telling him he's going to follow the law and get off the case, it's not helping my case. That is retaliation, flat out. Now, I realize there was a little space between me saying, you're going to get a lot of complaints, and then, it's not helping your case. But either way, the spirit of his statement is that he's somehow, by me implying that that he's not following the law, I believe he's not following the law, and that I'm going to file a Rule 10 or whatever, exercise my rights to get him off this case. He's saying it's not helping my case. Well, there's no other way to read that and hear that and as that he's going to hold that against me. He's going to hold me saying you're going to follow the law or get off the case against me. Why would it? Because if it's not helping, that means it's hurting. So why would that hurt my case? How does me saying that you need to follow the law or get off the case hurt my case? He would never say that to an attorney. He said that because I'm pro se, and it's clearly a threat. He's calling me threatening. He's using the word threat, which is a legal term of a Rule 10, as something that is going to hurt my case. How is it going to hurt my case? That's what I want to know. And he just ended the hearing. So I don't feel comfortable with a judge who's saying that it's me saying I'm demanding what I'm owed by these rules is hurting my case. So that's because I know you said 3 minutes, right?
Yeah, and you just landed it. Perfect. All right. So, Ms. Townshend, you have 15 minutes from the order to recall.
Come on, Rachel.
Your Honor, Mr. Myers has not shown anything suggesting that Judge Metcalf has an interest or prejudice that would prevent a fair and impartial hearing or trial in this case. What he's gone through is just his disagreement with the judge's rulings, which is not grounds for 10-1 and for a change of judge for cause. So when he's talking about the live stream.
So the prosecutor is basically saying that Lane hasn't provided any information or evidence that there's like some kind of a financial interest or some kind of a problem under Rule 10 that would mandate that the judge recuse himself. So, guys, it's getting late for me. I do want to continue this, but probably I think it would be better for me to continue it tomorrow and allow Rachel to make her counter arguments. And that would give me some additional opportunities to look up Rule 10, because in California, under a challenge for cause, you don't just have to show some kind of a financial interest or something like that, or something that would prejudice you. It could simply be that you could argue that the judge has some kind of a condition preventing the judge from perceiving the law and the facts in a just manner. And that would be, I think it's Code of Civil Procedure 170.1. And I believe that that's the equivalent of the Arizona statute. Now, really quickly, you know what I'm going to do, guys? If you'll stay with me, I'm just going to take a look really quick. I'm going to grok it. So Arizona, I'm going to read it to you guys. Arizona Rule. Give me 1 second. Arizona Rule 10, recusal of judges. And let's just take a look, and I'll just read it to you, and then tomorrow we'll come back and we'll finish up. So Rule 10 basically addresses changes of a judge for cause and as a matter of right. Okay. So as a matter of right in California, what we do is it's a little bit different. So in California, just to give you some jurisdictional differences, as a matter of right, I can file what's called a peremptory challenge under 170.6. And I often do when I have a judge that I don't like for whatever reason. And there's a lot of reasons why you might not like a judge. So you can just automatically DQ them and another judge gets assigned. But you only you can only do that once as a matter of right. And I think you have to do it on or before your first appearance. Now, I don't really know how it works in Arizona, but it looks like this is like a dual situation where Rule 10 covers both. And so that's what it sounds like to me. So really quickly, I'm just going to read it to you, because she's saying that he hasn't demonstrated anything showing that the judge has some kind of like a financial interest or something preventing him from being fair. So let's read what the actual section says because oftentimes prosecutors will just ignore the section that doesn't support their case. So let's just read it. So a party can request a change of judge if they show that the assigned judge's interest or prejudice would prevent a fair and impartial hearing or trial. This could include bias, conflicts of interest, or other factors that compromise judicial impartiality. So right off the bat, what I'm hearing the prosecutor say doesn't comport to what I'm reading in the statute, because Lane Myers has made many arguments. One of them is that the judge is basically prejudiced against him, saying if you hadn't chosen to represent yourself, none of this would be happening. You'd be able to file motions in a timely fashion. You'd be able to respond. But since you went ahead and decided to represent yourself, that's on you, Lane. You shouldn't have done that. And so what Lane is saying, wait a minute, I have a fundamental unalienable right to represent myself in this case. And by you denying me the ability to get jail mail, by you telling me I would have access to a law library when apparently there had been no law library for at least 2 years prior to me being incarcerated, that shows bias and prejudice against my case. And that's what he argued. So, and as a matter of fact, so that's Rule 10.1, that he can, as a matter of right, and then 10.1 would be as a matter of right, and then 10.1 would be changing the judge for good cause. So again, if Lane makes a proper argument that he's being denied a fair and impartial hearing or trial, it can include bias, it could include a conflict of interest, or other factors that compromise judicial impartiality. So I believe, based upon having externed for the California Court of Appeal, being an appellate attorney and understanding the different bases for disqualifying a judge over 20 years in practice now, that Lane Myers has made a valid threshold argument that it appears as though this particular judge has demonstrated bias on the record against Lane, an ongoing pattern and chain of abuse of discretion that could potentially warrant disqualification. I believe that Lane has met that threshold, and I think that it was disingenuous of the prosecutor right out the bat to simply say, well, Mr. Myers hasn't demonstrated anything that shows some kind of a conflict of interest. That's not what this is about. It's about whether or not he can establish a threshold showing a bias or prejudice or other thing that could potentially disqualify the judge. And so anything that could compromise judicial impartiality. And so that is, in my opinion, he's made that threshold argument. And what we'll do is, if you guys can give me the timestamp, it looks like 147. Well, 147 here. Let's look at the timestamp on the actual. So we're at 49:19 on This Is a Public Services video. So tomorrow, what I'll do is I'll come back and I'll do the prosecutor's rebuttal to Lane's arguments. But right off the bat, guys, I mean, it looks like the fix is in. Probably the judge denied it and ruled in favor of the state to allow Lane to get a different judge, which means he's got more time in jail, and that gives the state more time to push Lane to enter into a plea deal. And that's usually what this is all about, is putting pressure, because when you're incarcerated, you'll enter into an unfair plea deal just to get out of jail. And so when I look at this, I don't see anything based on her initial arguments. She's saying that the judge hasn't shown an interest or prejudice that would prevent a fair and impartial hearing. Well, I definitely could see prejudice. Now, an interest, well, Lane doesn't just have to argue like a financial interest, right? And that's what she's alluding to, that, well, the judge owns stocks in a company that the alleged victim owns, right? Or something like that, where you could argue a financial or some other kind of interest. Lane has made the arguments that he's being denied 8th Amendment due process, 14th Amendment due process, because the judge is just ignoring his motions and pleadings and making circular arguments about the judge saying, well, if you hadn't chosen to represent yourself, well, then you'd be able to get copies of motions and be able to respond to pleadings in a timely fashion. And that's not happening here. And so to me, when I look at Lane's arguments, if I was on the Court of Appeals in Arizona, I would rule in favor of Lane. I just don't see what the big deal is here. I mean, it's clear based upon statements made on the bench, in my opinion, that the motions and the procedural violations show that the court acted in an unfair and partial manner. And so, and I am biased towards the defense always, of course, because the state has unlimited power and unlimited funds. But tomorrow we'll go back over it, guys, and we'll see what you guys have to say after that. What do you guys think so far? Am I covering this well? Is there anything that I missed? Do you disagree with me about anything? Do you think that I'm a crazy person for supporting someone like Lane? It's okay. You can tell me in the comments. It doesn't really matter to me. The idea here is to get out public discourse, use the First Amendment to help people understand their rights and how a train of abuses could ultimately lead, in this case, to recall elections, which is precisely what I see the proper approach here. I believe that recall elections are probably the only way that Lane is going to get any modicum of justice here. And I believe that people like Lane Myers, people like Reluctant Prophet, people like This Is a Public Service should be running for sheriff, should be running for mayor, and should be making it their duty to try and change the system from within, because it's easy to throw rocks and be an armchair general or an armchair lawyer. But put your money where your mouth is, guys, and get out there, and I'll support you with my channel. I've got over 50,000 subs. I'm picking up a couple thousand subs a week, and I'll do whatever I can to sort of empanel and empower my subscribers to help you, to raise money for you, whatever it takes, to where we can do just like what George Soros is doing all across the country, by making sure that we get people into power who, instead of burn the Constitution, support it. And that's what I'm hoping to do with my channel here. And I appreciate, guys, the donations, the super chats, the memberships. Another way for you guys to support me, give me 1 second. If you want to support my channel, I'll give myself a shameless plug, and make sure to hit that like and subscribe button, is pick up a digital version of my ebook, My Journey to Becoming a Practicing Lawyer with No Law Degree or Undergrad, where I cover the basic requirements as they were when I became an attorney in California, how to become a lawyer with no law degree or undergrad. And I also cover the other states that still have law study programs where you don't have to go to some far left commie law school, right, where they teach you how to burn the American flag, and that all white people are evil, and that boys are girls and girls are boys. You don't have to do that. You can learn how to become a lawyer the traditional way, by learning logic and critical thinking. I tried 3 cases to the jury as a certified law student before I was even an attorney. And I'd done hundreds of depositions as second chair prior to becoming an attorney. And so practical skills and practical application, I think that's where it's really at. And classical education, reading the works of Thomas Aquinas, understanding John Locke, understanding natural law, actually reading the Constitution and the Bill of Rights. I mean, how many judges do you think have actually read any of those documents? They don't have you read the whole thing in law school, guys. They teach you black letter law. That's it. So anyways, guys, I really do appreciate you joining me today. And thank you, Nirenalmada. It sounds like a pretty Viking sounding name. And thank you to Tracy. This is a public service. I'm glad you joined, bro. So this is a public service. I covered for the last hour or so the audio of the hearing that you recorded of Lane Myers arguing for recusal. And I'm running out of time. My back's starting to hurt a little bit. So tomorrow I'm going to cover the prosecutor's counter arguments. But guys, give me a bunch of ones for This Is a Public Service. And make sure to like and subscribe to This Is a Public Services channel. And make sure to donate, whether it's super chats or buying memberships from him and Reluctant Prophet, because these two guys are like the modern YouTube version of John the Baptist. They're a voice literally in the desert in Arizona. And they're fighting for things that I've always believed in my whole life, which is empowering the people and speaking truth to power, and not just blindly following the state. And so these guys are awesome to me. So a bunch of ones for this is a public service. Thank you for joining me, Jody Shiloh, Mr. Osgood, and Bad Badger Troll account. I don't know what that means. He only has access. I guess the law library. He only has access to Arizona State cases. Is that what you're saying? And he doesn't have access to a law library. My understanding is he has to do his research online, which means he's going to be surveilled by the jailers. And so how can you really prepare an adequate defense when the state is able to surveil you? They did the same kind of crap to Eddie Gallagher, Chief Eddie Gallagher, U.S. Navy SEAL, who is incarcerated, and the prosecutors illegally put like some kind of a malware into his lawyers' computers to where they could surveil and find out what his lawyers were up to, violating all of his rights. It's just typical. That's why you can never trust the prosecutor, because they'll do whatever they have to make sure that they can get elected to the next highest office, many people say. And so I always err in favor of we the people over the state, because we know that absolute power and money corrupts absolutely. So I appreciate you pointing that out, Bad Badger Troll account number 172. And What's the Matter You? Thanks for all the ones. And guys, thanks. What's the Matter You? This was What's the Matter You Wednesday. I'd love to have What's the Matter You come on as a guest as well sometime to talk about things, just shoot the breeze. I've had Ralph Riley on before. I just like having regular people on the show. I'm not trying to impress you or prove that I'm the best lawyer in the world. I know that I have God on my side, and that I am speaking from a spiritual point of view that is incontrovertible and true and pure. And so I just love it when I have regular people who also feel the same way. It's very rare that you'll find a lawyer who actually has those types of beliefs. Black letter law and being brainwashed in what I consider to be like political re-education camps, public schools, colleges, and law schools basically creates cookie cutter Marxists, in my opinion, who don't support the Constitution or the Bill of Rights. Give me a bunch of ones if you agree. So let me see here. Tao Tracy says, is Michael Ehline is wrong to think it's good for RP and Foshin to run for sheriff? Well, I don't think it's wrong. I think that the Shire of the Reef is the ultimate arbiter and protector of our rights. And if you look up the historical job of the Shire of the Reef, you'll see that for yourself. But it's okay for you to have a different opinion. But I think that it's very important, instead of throwing rocks and being armchair lawyers and armchair generals, that people that have our minds get into positions of power. I mean, look at Obama's friends. His attorney general was part of the Weather Underground, where they were bombing universities, burning American flags. And Obama got his anti-American people in charge of the judiciary, as well as in charge of the prosecutorial system. And they're still there to this day, guys like Comey, right? People who obviously just support big money, George Soros, and the globalist agenda. So why can't we as normal Americans reclaim our birthright as Americans? It's just an idea. You don't have to do it. But I appreciate that. And Sin City Giggle says, I love you, Michael. You're organic. That's one thing you definitely can't accuse me of not being organic. So I appreciate that. But it all stems from my childhood, being reared up by a combat veteran who was betrayed by his country during the Vietnam conflict, Marine as well, who died from Agent Orange, non-Hodgkin's lymphoma. We were lied to about the Gulf of Tonkin, and we were lied to about the weapons of mass destruction in the Gulf War. It's just come out recently that the mullah in Afghanistan was given 48 hours to turn over bin Laden, and on the 40th hour, we invaded. And he did say that had they given him the extra 8 hours, they would have turned over bin Laden. So it's kind of hard for me to just blindly follow the government. I want to go back to the old Russian saying, I think it's called Dolvaye Naprovaya. It's like trust but verify. So I'm not saying don't distrust your government, but don't trust them until they verify. It's that simple. So with that being said, Nyrenalm says, do you think if Lane got some decent food, maybe he could make some better? Absolutely. Of course. I mean, getting better food, getting into a position where he has access to a real law library with federal and state cases and several hours a day to do legal research. a computer with a printer to where you can do responsive pleadings and motions, the ability to use the mail, the ability to get things filed in time so you're in compliance with the civil procedural guidelines, of course. Absolutely. Totally unfair. And good seeing you, Kevin Biernarski. And now I don't know if anybody gave me any super chats or donations. I just want to scroll up to make sure I thank you if you did. So just give me, it's going to take me a while. Gosh darn it. Because I wasn't looking at the screen the whole time. So I just don't know. Now there's just too many comments, guys. Well, look, if anybody who donated to the channel or anybody who supported me today or bought a copy of my book, I'll go through tonight when I'm editing the video for making shorts, and I'll take a look and I'll give you credit tomorrow. But I do support I do appreciate any kind of support you've given me. And Daniel Bruins, Kevin Biernarski, Tom Show, Letso TVO, Chili DeCastro, all you guys, I do appreciate it. I am going to try and arrange to get Chili DeCastro an interview with Lane. I think that both of them, there are many parallels with their situations where Chili was also unjustly arrested and imprisoned and got his case reversed on appeal. And I think that we really need to be sending Lane letters, mail, helping him with his commissary, letting him know that people support him while he's doing God's work, even though I think he's an atheist. But you know what I mean? Doing the work of we the people to try and stand up for what's right in the only way that he knows how. So with that being said, guys, make sure to like and subscribe. Oh, look at there. I just got $5 from Howard Clegg. Thank you, Howard, for supporting my channel, brother. It means a lot to me. I know that $5 to some of you guys might be $3,000 to somebody like me. And so that really means a lot to me, big time. Supporting my channel definitely helps me when I'm trying to argue with my wife why I'm not working on cases and instead doing what I love doing most, which is my YouTube shows. So believe it or not, I love doing these shows. I love getting the word out because so many of you guys just get disinformation, or you've got these shock jocks on YouTube who really just don't care about anything but getting a bunch of subscribers and views. And there's a lot more to life than that. My goal here is to educate you and give you the ability to arm yourself with the armor of God, being able to use the law as a sword and a shield. So with that being said, make sure to like and subscribe. Make sure to double tap that screen, guys. Double tap, press that like and subscribe button, as Chili would say, because we never know when the thought police are going to take down this channel. So make sure to save these videos to your computer as well, like upload them. Because if I lose this channel, we're going to lose all these shows too. And this stuff is thousands of dollars worth of material, probably hundreds of thousands in my time over the last year creating these. So if anybody can help me upload these videos and create a library like on Patreon or somewhere else, please help me do so. Because again, you never know when the thought police are going to try to take down this channel. So with that being said, Semper Fi, do or die.